Hi, welcome to today's video on the Law Show. My name is Dele Igbinedion. As you know, if you have been watching our videos, but if it's your first time passing by here, I'd like to welcome you to this Law Show where we discuss nothing but law, help you to understand your legal rights so that you can actually, take informed decisions and action your rights. I talk about actionable legal information, not just legal information that is placid or dull or insipid, but the one that is actually actionable that you can really use, to either defend yourself or assert your rights, anytime that you have to. In this video, we'll be looking at how to improve Nigeria's justice system. Now, this is something that has bothered lots of people, and there's been all kinds of comments and theories and positionings on this point. But I want us to look at it in this video, how to improve Nigeria's justice system. And we all know, we all agree that Nigerian justice system is notoriously corrupt, notoriously slow, and notoriously in need of overhaul. So what can we do? What are your thoughts? What are my thoughts? How can we improve on it? So I'll be right back, and then we'll do this video on how to improve Nigeria's justice system. Don't go away. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. Okay, so first off, let's just get it off. This is not to knock anybody, and it's important that we start off on a fair note between both of us, between me, the speaker, and you, the viewer, and whoever, because this is a conversation that we must have, how we can improve the Nigerian justice system. Because number one, our system is notoriously slow. You have cases that last in court for years and years and years. And on this program, on the Law Show, we've done how to get quick justice, if you recall, how to use ADR, alternative dispute resolution, to get quick justice. That video is there. If you haven't seen it, you can of course look for it through our combo and watch it. Now, I've also written some things on this system, comparing the administration of criminal justice in Nigeria with the administration of criminal justice in the UK, so that we can pick up one or two things from countries that are civilized. Now, some people say Nigeria is civilized. Some people will say it's a developing country. They call it a developing country. It's just developing. It has not developed yet. We are still developing, So are we from 1 to 100? Where are we on the scale of development? Are we number 2, or are we reached 30 or 40 or 60? But I think your guess is as good as mine. But my own as a lawyer is to look at the justice system and how working together we can improve it. First off, I talk a lot about. Is it first off or second off? I think I've talked about first off. Okay. We've looked at human rights, enforcement of human rights, because that's something that is really dear to my heart. Enforcement of human rights. One area in which we need to realize that technicality is killing human rights enforcement in Nigeria, and you never ever can actually rule yourself out of becoming someone who will be in need of his human rights to be enforced. You never actually can rule yourself out. It doesn't matter who you are today. You could be the general in the army, you could be the chief justice of the federation, you could be chief judge of a state, you could be a commissioner of police, you could be a brigadier general, whatever you are. You could be a local government chairman or a governor of a state. Don't forget that one day you also could be in need for the enforcement of your human rights. So, technicality. And what do I mean by that? In Nigeria, for you to enforce human rights, you need to choose a specific category of court. In fact, there are only 3 courts where you can institute a human rights claim: either the High Court, the Federal High Court, or the National Industrial Court, if it's And I think we've done some videos on it. You can look for the different jurisdictions of these courts in terms of enforcement of fundamental rights. But we can just briefly say, if it's something to do with the state government, you go to state high court. If it's something to do with federal government or federal government, federal government, you go to federal high court. If a human rights issue arises from employment situation, you go to the national industrial court. So these are the three courts now. And when you get there, you file your suit. Then you must make sure that the human rights case which you are postulating, which you are complaining about, is the principal relief, is the principal claim, and not an ancillary claim. So the courts have introduced this concept of there's a principal claim and there's an ancillary claim. And some claims are principal, some are ancillary. So, oh my gosh, which one is principal now, which one is ancillary? So the smart lawyer has to be able to distinguish between principal claim, ancillary claim, and all of that. If you ask me, I think it doesn't make sense. Sorry to say, it doesn't make sense, because I don't know where we got it from. Anyway, as far back as I think it was governor of Gongola State and Emir of Muri or Emir of Mubi or whatever, one of those cases that arose from the old Gongola State when Yohana Madaki removed, the former Emir, and then he had to go to court. And when he got to the Court of Appeal and up to the Supreme Court, they said, "Oh, your principal claim is not it's not a fundamental right thing. You are seeking your office as an emir, so your traditional stool is your principal complaint. Consequently, you should have gone to the state high court, shouldn't have gone to the federal high court, and this and that, or you should not have even used the fundamental rights procedure." So a case that was fought from the high court, federal high court, or high court up to the Supreme Court failed on that point. And there has been many cases that were buried on this point. Now, I think, if you ask me, that is a technicality taken too far. Technicality taken too far. First off. Okay, I'm always saying first off, isn't it? So let's just accept. First off, everything is first off. First off, there is no reason under the sun why only high courts should entertain fundamental rights cases. I mean, why? Is it because only judges of high courts, state high court, federal high court, and national industrial court, are they the only ones with the requisite intelligence, the requisite experience, the requisite legal knowledge to be able to entertain fundamental rights cases? I say no. Why? In England, and you can take me up on this, in England, you have a claim form to institute your action in every court. So you have, for example, in the county court, which is like the lowest level of court in Nigeria, like the area court or the customary court, you want to institute your action there, or a civil action in the magistrate court, which are also at the lower strata. There is a column you must tick whether the case engages a human rights issue. They will ask, is a human rights issue engaged by this claim? You say, yep, it does. You tick it. And then you have to explain. And that court will deal with your case and deal with the human rights issue. So if you are filing an appeal against a decision of a lower court in England, you must also tick in the notice of appeal form, does your case engage a human rights matter? So the courts are open to hear the human rights complaint. They are very open. They are not being discriminatory as to whether it is ancillary or whether it is the principal claim or whether you have gone to the proper high court or you have not gone to the high court. No, court is court. So that is what I think we should also be mindful of in Nigeria. Number one, we should be able to remove this restriction that only high courts can entertain human rights cases. Okay, so that's number one. Can we turn to use the camera? That's number one. Number two, so that's number one. I hope you got that. Number two, I also worry, because I also worry about the insistence that only the judges at this level should do this, cases. And the second issue that arises from that is, how can we improve the background knowledge or experience of judges on human rights issues? Because now you have the EF's Economic and Financial Crimes Commission doing all kinds of seminars on money laundering, anti-money laundering, inviting judges, the National Judicial Council, National Judicial Institute doing all these, seminars. for judge, but we need to do a lot more, because if our constitution was smart enough to have dedicated a whole chapter to the issue of human rights, then it means we must also give it the pride of place in our legal training for judges, legal training for lawyers. In fact, the whole world has left Nigeria behind on the issue of human rights. In Nigeria, for example, we're still talking about freedom of the press, freedom to express and hold, freedom to hold and express opinion. We are still battling with that elementary concept. Whereas other countries have gone far ahead of it. You know, they've gone far. They now talk about not just that right as a constitutional issue, but also as a private issue, as a private law issue, you know. So this is not the subject for talking about. But my point is, we need to be able to introduce a system for interrogating the human rights experience or background of potential judicial officers. Let's not just assume, with all due respect, that everyone appointed as a judge will just automatically and miraculously, you know, understand human rights and you know, dispense human rights. It requires a particular kind of sensitivity. Yes, it does, because you know, it takes a sensitive judge to be able to distinguish, and I'm saying this with all due respect, okay, to be able to distinguish between, okay, the man was detained for 3 weeks, but he was eventually charged to court. Some judges will tell you, well, he's been charged to court, he's been charged to court. Why don't you just deal with the, you know, case? After all, there's now a criminal case hanging over his head. Why don't you deal with that? It takes particular sensitivity for a judge to say, you know what, hang on, how come you detain him for 3 weeks? You ought to pay for that. Okay? Now, another point that arises from this is, we have a law, the Evidence Act 2011 in Nigeria, where we Nigerians promulgated that any evidence is admissible, irrespective of how it was obtained, irrespective of how it was procured. Whether you procured it through illegal means, you broke through a window, you broke through a door, provided you have the evidence, you can tender it. My God, I could never get my own head around that one. That one is the one that always shocks me. Because in proper democracies, in proper countries, once the security agencies breach the law in doing anything, then everything that follows thereafter is a nullity, completely nullified. In other words, you cannot, in trying to uphold the law, break the law. You know, I mean, it makes sense. You cannot, in trying to say, I'm upholding the law, you decide to breach the law, break the law, or whatever you want to call it. So you that is an upholder of the law, you need to be able to uphold the law, you know, from A to Z. So, for example, statements that are obtained involuntarily from confessional statements that are obtained by duress. You find out that if you study jurisprudence, or in the United States, in Canada, you know, advanced countries, even Ghana here, they are more sensitive, you know, to rejecting it. They don't want it at all. But Nigeria, we try to whittle it down under Section 29 of the Evidence Act by talking about, you know, removing, you know, force and all those things, and saying if it was obtained in circumstances which inhuman and degrading treatment and things like that. Then we start to define human and degrading treatment as torture or circumstances that could be considered to be torture. But you know that you can obtain statement without torturing the person. You can actually break. You can, for example, police arrest people these days without, they don't even go for a warrant of arrest. They don't even bother magistrate to sign warrants anymore. Unless they want to do it, you know, across border or something like that, or across states. Sometimes they don't even bother. And then somebody will be arrested without a warrant and hauled before a court, and then the court or the judge will see nothing wrong, you know, in that. So we need to interrogate these things. These are questions we need to agitate our minds with if we must improve the Nigerian justice system. Non-negotiable point. Once any evidence is obtained illegally, it should be excluded from a legal criminal trial. Non-negotiable. Non-negotiably. No discussion about it. It must be excluded. In fact, in the United States, you remove it by what is called a motion to dismiss. You have a motion to dismiss evidence or a motion to exclude evidence. And to be excluded. Why? Because you cannot use illegality to establish legality. You can't do that. Nobody will take that from you. Okay, so that's on that. I hope I still have some time. Okay, now I have a few more moments. Let's just talk about another one. I believe we need to deal with, to improve the Nigerian justice system. It's just a simple step. Now, this one does not depend on the executive for us to do, because if we wait for the executive, they're not going to do it. Legislature can do this one. And the NBA as a body can do this one. Something about the independence of judges. Independence of judges now. This is an issue that has been talked about. I'm not going to rehash all the political, economic, sociological issues around it. I'm more interested in the law. Now, the rules of professional conduct, and this is important, the rules of professional conduct debar a judge. Once you have been a high court judge, you cannot practice law anymore. I keep wondering, why did they make that law? Why? It's in the rules of professional conduct. It's in the Constitution of the Federal Republic of Nigeria. What nonsense? Utter nonsense. Why? So, if a judge is been appointed as a judge, and for whatever reason, either because he was unfavorable to the government in power, he gets dismissed, he gets shoved out for whatever reason, that's the end of his career as a judge. It's also the end of his career as a lawyer. He can't go and take up his wig and gown and begin to practice law. He can't do that. Why? Say, oh, well, he will now appear before his brother judges and be arguing cases. There's a tendency for favoritism. No. Judges are trained to insulate their minds against such things. If you don't do well, whether you are a former judge, if you come before a judge and mess up, you will lose the case. So, I advocate that we should remove, and speedily too, that forbidding of former judges from practicing law. They should be allowed to practice law if they so desire, after retirement, after dismissal, or whatever. Because if a judge is to be independent in his mind, he must be independent in his pocket. If he's not independent in his bank account, he can never be independent in his mind. He can never be independent in his judgment. So you need to give a judge the opportunity to say, you know what, if you push me beyond my pressure limit, I just resign, I go and practice my law. After I was doing well before I became a judge. This is what judges in the UK and in the United States are able to do. Canada, other countries are able to do it. That way you can't push a judge too far. Somebody can be sitting on the bench yesterday and tomorrow he resigns, he's appearing in court arguing a matter. So that's something we should think about if we need to improve justice system in Nigeria. Because take it or leave it, most of our judges, they live in fear and trepidation. Nobody wants to lose their job. Because they're afraid if they lose their job, what else can they do? What else can they do? They can't just become mechanics or start selling tomatoes. So sometimes they have to be quite circumspective, where circumspection is not called for. They become introspective where introspection is not called for. They become over careful where carefulness is not called for. They don't charge where the law requires and the circumstance require them to charge. So I'm saying, for those of you who are watching, lawmakers, advisors to lawmakers, because we lawyers are the ones who actually draft all these laws, we should be able to, ameliorate this so that judges can practice law. Okay. Now, final point I want to make, I hope we still have a little bit of time, how to improve Nigerian justice system is to ensure that we have courts that sit on weekends and public holidays. Yep. You can't have court sitting Monday to Friday, no court sitting on Saturday and Sunday. And then the Constitution says you must not detain anybody beyond 24 hours. So if somebody is arrested on a Friday, there's no court to charge him before Saturday or Sunday. And sometimes Monday is a public holiday, so the person will be in detention. And then we always, when we argue human rights cases, say to police, well, the law says you must charge before 24 hours anyway, or release on bail. So if you don't charge, you are liable. This is your problem. But there is an institutional infrastructural problem. In England, there is a judge round the clock, 24 hours. There is a judge. When you have vacations, you have a judge sitting there in the high court or wherever, in his house. And if you have an urgent matter, when I was practicing in England, I had an urgent matter. I called the court. The court system had there's a phone number, emergency phone number for it's called out of hours phone number. So you call that number when the court is closed. You explain yourself, you identify yourself, they confirm you are a lawyer, and then they give you the phone number of the judge. You call the judge, explain this is urgent. This person is about to be deported, or there's this problem, or we need an injunction immediately, otherwise this thing will go out of hand. And then what would the judge do? In that case, he wrote a decision on a piece of paper, asked me for my fax number, stamp and sign it, faxed it to me, and I told me fax it to the immigration authorities to stop deportation of somebody. See? But in Nigeria, you must file the case, file a motion ex parte, file a motion on notice, go and serve them at their headquarters. That is nonsense. It's nonsense. You must go and serve a company, a commission, incorporated body, serve them at their national headquarters, and then the chief judge has to assign it. It has to go to a judge who will now fix a date before you now go and serve. And all this while, your client is in detention. How does that work? So I submit on this point that we should, we should employ enough judges, have judges that are, whether we employ enough, we don't have enough, remove this human rights enforcement from high courts, bring it down to magistrates, so that perhaps on weekends we can have magistrates that are on call. Why not? Okay? So it's a conversation. Let me know your thoughts and your comments. Comment section. Subscribe to YouTube channel. Give us a thumbs up. Click the notification bell. You know what to do. Blah, blah, blah. All right. See you in the next video. Bye-bye. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV.